recording. Sorry. You
All
can
right.
continue.
Okay. So would it be possible for you to do the opening mantra? Do the opening mantra today, please. All right.
Yes.
So,
Yes.
namaste and a very warm welcome to everybody for the second day of the workshop on introduction to traditional knowledge, intellectual property, and people's rights. I request our research fellow Piyush ji to please start with the prayer.
ॐ सहनाववतु सहनो भुनक्तु सह वीर्यङ्करवावहै तेजस्विनावधीतमस्तु मा विद्विषावहै ॐ शान्ति शान्ति शान्तिः
So thank you very much. And I think without delaying any further, I request Dr. Vishwajanani ji to please take over the session and do the second day for this present workshop. So over to you, Vishwajanani ji.
Thank you, Anuradha. Thank you, Piyush. Anil, you can share your presentation. Namaste to everyone, and a warm welcome once again to this workshop of the IKS division and the CSIR TKDL. So here we are going to talk about traditional knowledge in the context of intellectual property and as well as the people's rights. Yesterday we gave you a glimpse of what the expanse and depth of our Indian traditional knowledge has. And today we will continue with the workshop talking about the fundamentals of intellectual property rights. The way we have structured this workshop is to kind of provide you a background before we get into the actual details of, the intellectual property rights as well as the people's rights when we are talking about the traditional knowledge. Somebody has put up a message that they are not able to hear me. Am I audible? Anil, can you confirm? Am I loud enough?
Yes, ma'am, you're audible and loud enough.
All right. Okay,
please
thanks so
continue.
much. Yeah. So today, my colleague Anil Kumar will be giving you the fundamentals of intellectual property rights. So again, as we mentioned before, I asked him to continue with the presentation. Just a couple of announcements. There are several of you who had been part of the first workshop and have joined us here once again, seeking certificates. As Anuradha ji mentioned yesterday, the participation certificate will be given to all the participants who have, aligned with the requirement of 80% attendance in the workshop. And whoever has cleared the test that we have given on the 5th day would all be, as per the internal deliberations that we have handled, you will all be provided a merit certificate. This is in addition to the attendance certificate. The second query was on the PowerPoint presentations. We will be sharing the PowerPoint presentations with you soon. We will create a link and then we'll share the information with you. Until then, as I had mentioned, on the YouTube Acti Media link, you would be able to see all the presentations that are being made every day at this workshop. Even the presentations that we had made on the first workshop are all available for free viewing. So whoever has any concerns or doubts on a particular session is requested to refer back to those YouTube videos. In case there is a pressing need for you to contact us directly for any clarification, please do not hesitate. You can write to us anytime, and I will put up my email in the chat box once again for you. Thanks once again for joining us today. Anil, without any, I will share the YouTube link. Anil. Yeah, go ahead. You're on mute, Anil. Anil, you're on
So this
mute.
is the day 2 of, the workshop. This is batch 2, and we are going to discuss about the fundamentals of intellectual property rights. So there will be we'll discuss IPRs for 45 minutes and we'll take questions after that, maybe for 15 minutes or so. So if we talk about intellectual property rights, basically, IP, intellectual property protects the creation of mind. So when we talk about creation of mind, that can be an invention, it can be a literary or dramatic work, it can be, something artistic or some designs or symbols that we are using, creatively to designate our products or services. So intellectual property rights, unlike the tangible rights, have certain characteristics which can be used for monetary gains also. So when we talk about intellectual creations, they are properly protected under, the governing laws, then it can be exploited for a certain limit, a limited period of time to gain monetary benefits, and those inventions or creations can be further improved upon to create a new invention. So when we talk about this camera, so once it is developed, we have certain, characteristic features which can be protected under various acts, like the mark which has been used can be trademarked, the inventive concept can be patented, then we have a design in that which can be protected under Designs Act. Then all these features can be separately protected and exploited for commercial gains. However, it allows the companies and the inventors to get benefit out of their intellectual creations. So when we talk about IPRs, as I discussed, these IPRs can be copyrights. These can be patented. Copyrights were granted for literary, artistic, dramatic, or musical works. Then when we talk about the inventions, then patent rights are granted for the inventions. With regard to trademarks, these are the legal rights which are assigned for signs and marks, which are used to distinguish the goods and services of one trader from the other. Likewise, if we talk about industrial designs, these are the ornamental and aesthetic aspects of intellectual creations. Another type of IPR that we are going to discuss is geographical indications. These are the indications which which have a linkage towards the reputation and characteristic of goods, which is linked to a certain, a specific jurisdiction. And apart from that, we are also going to discuss about plant variety protection, which is granted for new plant varieties. So first of all, we'll discuss about patents. So when we talk about technical inventions, so these technical innovations or inventions are protected by patents. And the right granted under patents is limited for a period of 20 years, and it is given for a technical solution given to a certain problem that existed. And when we talk about the subject matter, it can be a product having a technical solution or a process. That means a new way of doing something. So a product is given for a product and process, and there are certain essential requirements for getting a patent. The first essential requirement is that it must be a product or process, as we discussed. Then it must have novelty. Okay, so novelty is like in case something is known earlier. Okay, if we see, something which was which existed in nature. So in case we try to patent that, it is not patentable because it lacks novelty due to the prior art that existed. Okay, so it must be novel. So, and another essential criteria that is required is the inventive step. That is, it must not be obvious to a person skilled in the certain art in which we are filing the patent application. Another essential ingredient is it must have an industrial application. Okay, so in case something, some invention which doesn't have an industrial application is not patentable. So it is an essential requirement. And the another criteria is like it should not fall under the prohibited patentable subject matters as classified under Section 3 of Patent Act and Section 4. Okay, so in case any of the invention which qualifies all these essential requirements, a patent is granted under the respective law in that country. So if we talk about the purposes and mandate of, the mandate of granting these rights, so the basic and the foremost purpose for granting patent is to promote technological innovations. So when something is invented, it must be disclosed to the public. So the rights which an inventor gets through this patent is like he can now exploit that technological innovation for a certain period of time, but the mandate, in return, the public should know the technology in detail. Okay, So once that technology is disclosed to the fullest, and when the term of that patent expires, it must come into public domain so that others can use it. So this is the prime objective. And another objective is that for that certain period of time, which is 20 years, a fair commercial reward must go to the inventor. And the last one is like, there must be a proper documentation, publication of technical information, so as to improve those technical inventions further. So this is the statutory definition of invention as per Indian Patent Act 1970, which says that invention must be a new product or process and must involve an inventive step and capable of industrial application. So if we talk about one of the inventions that is given here, if you see this cycle, so we all know when we cycle, the lower part of the body, it is employed in cycling, and upper part of the body remains. It doesn't work as compared to the lower body. So considering the gap in the technological invention, a new cycle was patented in the year 1900, long back. At that time, that was it might have an inventive step, but as of now, it may be obvious to a person. However, if you see the invention, it has the combination of the cycling characteristics, and there is a rowing mechanism attached to it, wherein the upper part of the body can also work. So this was a patent which was given to the inventor in the at that time. So if you talk about the subject matter of patents, patents can be granted for apparatus, devices, machines. So if we talk about this doorbell camera, it is patentable. It can be granted for chemicals. It can be granted for drugs, food and their compositions. Biological processes with human interventions are also patentable. Then biological products are also patentable, and the process for manufacturing all these products are also patentable. So these are some of the examples where you can see an umbrella which is upside down, and it can also be used as a stick, walking stick. So it is quite inventive, and the patent was granted for it also. So likewise, if we talk about drugs, vaccines, this chair, the drones, and these roofing materials, all these things are patentable under Patents Act. So if we talk about the prohibition, so there are certain inventions which are not patentable in India. So although they qualify the requirements which are prescribed, those 4 parameters which are essentially required for granting a patent, in case they qualify all those parameters and fall under these categories, they are not patentable. So if you talk about section 3A, it clearly says that frivolous inventions are not patentable. So if we talk about a machine which is having a constant motion without any force applied to it, it is frivolous. Okay, so that invention is not patentable in India. Or if we claim something which has a device which is having 100% efficiency, that is also frivolous in nature and is not patentable under section 3A. Likewise, if we see section 3B, in case an invention is contrary to the public order or morality, or it's causing serious prejudice to the health or human, animal, or plant life, is also not patentable. Okay, so in case we invent something, a device which is helpful in committing theft, that is against the public order, okay, and it is not patentable. Likewise, an invention for cloning humans is also not patentable under section 3B because it is having a serious prejudice. Likewise, if we see section 3C, discovery of scientific principles or discoveries or discovery of living things or non-living substances in nature are also not patentable. Okay, so if we talk about Newton's law or any law of nature, which is there, so those things are also not patentable. Likewise, in section 3D, if we see the discovery of a new form of known substance or new use of known substances, are also not patentable. So in case we have a drug which is known for an application, so it's used for a similar similar application is not allowed under section 3D. If we see section 3, it says mere admixture leading to the aggregation of properties is also not patentable. So if we talk about the admixture of substances, is like in case we have a cold drink wherein we add a substance to give a color, then it will be merely aggregation of 2 known properties. So that is not patentable under section 3E. The next section is section 3F, wherein an invention which is mere aggregation or duplication of devices in a known way is also not patentable. So if we talk about section 3F, if we have, I mean, we develop something or invent something, I mean, we develop a fan, I mean, attached to a chair. So that is also not patentable because it is merely an aggregation and duplication of two known devices whose working is known. So if we see section 3H, it says methods of agriculture and horticulture are not patentable. So the cultivation of algae or a method for preparation of soil for cultivation, these things are not patentable because they fall under section 3H. They are prohibited from being patented under Indian Patent Act. Likewise, section 3I, it says surgical, curative, prophylactic, diagnostic, therapeutic process or process for the treatment of humans and animals is also not patentable. So if we see, I mean, if in case there is a surgical method for removal of tumor, so that method is not patentable since it falls under these prohibited categories. Likewise, section 3J, it says plants and animals in whole or any part or seeds, they are not patentable. However, microorganisms with human interventions are now possible for getting a patent. Okay, so under section 3K, mathematical business models and softwares are not patentable. Under section 3L, cooperatable subject matters and subject matters of design, they are also not patentable. Likewise, in section 3M, scheme or method for mental act or playing game, that is also not patentable. And then under section 3N, presentation of information, like the way we present something, okay, the voice, okay, the presentation pattern, these are not patentable. Integrated circuits are registered under a separate law. That's why section 3O, it prohibits registration of integrated circuits under Patent Act. And the most important is like section 3P. So the inventions that are in effect traditional knowledge or they are aggregation of known properties of traditionally known components are also not patentable under Indian Patent Act. And additionally, section 4 says that atomic energy inventions are also not patentable under Indian Patents Act 1970. So these are the prohibitions under. Yes, if we talk about the process of patenting, I mean, we have to file a patent application before the office of CGPDTM, that is Control General of Patent Designs and Trademarks. So it has offices across India. There are 4 offices for filing patent applications. One is in Delhi, Mumbai, Chennai, and Kolkata. Okay, so each state is falling under the jurisdiction of specific office. So the person, I mean, who is having a place of residence or doing commercial activities in those jurisdictions, they can approach the respective patent office and they can file a patent application. So they can file a patent application either provisionally or complete. Provisionally is like in case you have something more to, I mean, do in terms of making a invention complete, then you can file a provisional application wherein you have additional 12 months to file the complete application, or you can directly file a complete application. Okay, so once a provisional application is filed, then within 12 months, you have to file a complete application. Otherwise, that application will be abandoned. After filing a patent application, then it is published after 18 months of filing. Okay, in case you want to have an early publication, then you can file a request for early publication, wherein the patent application will be published within a month. Okay, so in case you want to publish it or you want to make the public aware that you have filed something and you want to have some rights, I mean early rights in that application, then you can go for early publication. So once this patent application is published, then it is examined. So the request for examination can be filed within 14 months from the filing date. However, this can be filed at the time of filing the patent application also. So in case you are not filing a request for examination, your patent application will not be examined. Okay, so it's a must. In case you want to get your patent, then you have to file a request for examination. Meanwhile, I mean, there is a provision of pre-grant opposition. After the publication of patent application, in case somebody feels that, I mean, the patent application which has been published is either in violation of the prescribed, I mean, rules and regulations of Patent Act or is, I mean, falling under the prohibited categories, then one can file pre-grant opposition to oppose that patent application. Okay, so all the, I mean, this examination process and pre-grant opposition has to be completed by the examiners, and the examiner can either grant or deny the patent. In case it is granted, then the person who has got the grant can enjoy the benefits subject to the renewal of patent application. However, in case there is a denial, then they can go for appellate proceedings Okay, and there is a provision of a post-grant opposition and revocation patent after grant of the patent. This is the whole process. And if we talk about the infringement process, in case somebody, uses or do certain activities with related to a granted patent, then it is then infringement, and the person is liable to be, liable to be, action is an action is pending against him under the law. So if we talk about the infringement of a making, offering for sale or selling or importing the patented product in India without the authorization of the inventor or the person who is owner of the patent is prohibited in India. And with regard to the process patent, using, offering for sale or selling or importing the product obtained directly by the patented process is prohibited without the permission or authorization of the owner of the patent. And when we talk about the the infringement of patents, it is basically divided into two categories. One is direct and indirect. So direct infringement is the most, the common type of infringement that happens, wherein the elements of one invention are copied directly, or the elements of that invention are literally same. Okay. Or if we talk about the direct, the infringement under doctrine of equivalent, then the activity is performed almost in the similar way to achieve a similar effect. So in that case, there is no literal similarity in terms of infringement, but the way the invention performs or behaves to deliver the similar effect, is termed to be an infringement. So it's somehow more technical as compared to the literal infringement. With regard to indirect infringement, it is basically, a support from a third party to make, to infringe the rights of a patent owner. So when we talk about inducted infringement, then there is an inducement from a third party. Okay, so that inducement may be, quite this inducted infringement is like when somebody, some third party helps you to, infringe the rights of a patent owner. However, if we talk about the contributory infringement, then the liability of inducing you is absolute in nature. And in the vicarious liability, that infringement has been made out, and both the parties, the actual infringer and the contributory part, the party who has been contributory, both are liable for the prosecution under the the respective patent laws. So this was all about patents. Now, if we talk about copyrights, copyrights are the bundle of rights which are given to artistic, literary, dramatic and musical works. So basically, if we talk about copyrights, they are basically artistic and creative in nature. Patents, they are more of having industrial applicability, but these copyrights, although they have industrial applicability, but they are in the nature of authorship. So the element of authorship is there in copyrights, and to these are considered to, these are the exclusive rights given by the law for a certain period of time to the author. And there are certain rights which are granted, like to publish, to reproduce and sell the copies of the original work. So if we see the purpose of these copyrights, it is to encourage creativity. The prime objective is to encourage creativity. It also protects the efforts of the author and motivates the authors to create further. It also gives rewards or monetary benefits for their creative creative efforts that they have given, and it grants the exclusive right for a limited period of time. And it also gives right for the the dissemination of copyrighted works. So if we talk about the subject matter of copyrights, it protects a wide range of works. So if you talk about literary, dramatic and musical and artistic works, they have to be original in nature. So poems, stories, novels, plays, shows, composition of graphical notations in terms of music, artistic paintings, sculptures, they have to be original in nature. However, if we talk about cinematographic film, that is also copyrightable, then the originality is not required. However, the elements of cinematographic film can be a combination of dramatic, musical, or literary work, but it has to be original in terms of expression. So if you talk about the grant of rights in copyright, it has to be expressed on a tangible form. Likewise, sound recordings are also copyrightable. However, the originality requirement is not there. So these are the basic parameters for copyrightable subject matters. So if we talk about novels, if you can see, the sand art, which is disclosed there, it is also copyrightable, protected under copyright. So if we talk about the rights which are given to the owners of copyright, so they have the right to reproduce their work in several forms. Then distribution, they can regulate and control the distribution of copies. They have a control over the public performance of their work. They can also regulate the broadcasting and communication of their work to the public. In addition to that, the translation of their work is also under the Copyright Act, and they can regulate the translation. They can permit or restrict the translation of their work into other languages. And lastly, the adaptation, it is also covering the adaptation of work. So in case we want to have a movie, made out of a novel or a screenplay, then the permission of the copyright owner is to be taken properly. And when we talk about the rights, there are three categories of rights that are granted to copyright owners. First is the economical right, wherein monetary benefits are involved. Then we have moral rights. So moral rights talk about the paternity rights. So the author of the work has the right to his work should be linked to his name, and he has a right to restrict the distortion of its work. Additionally, these performers' rights are also there. These are separate from the copyright. And in case somebody, who performs like a musician, in case he performs or an actor in a movie, so he has a performer's rights which are separate from the copyright. So he can, a permission is to be taken from the performer also, in case you want to reproduce the work. So if we talk about the remedies for infringement of copyright, we have civil remedies, criminal and administrative measures. So we can go for civil suit for injunction to get damages for accounts and cost, apart from the criminal provisions, wherein there is a provision for infringement and fine also. With regard to administrative measures, we can approach the custom authorities to restrain the entry of those infringing works into the border of India or any other country. So the another type of intellectual property right is trademarks. So these are the signs or indications which are used by the person or company to identify, to designate their products. So if we see this, these symbols which are given on this slide, if you see these symbol of Mercedes, it is quite clear that this, in case this symbol is there on a car, you can directly relate that product to the manufacturer. Okay, so these are the signs which indicates the source of product or services, and it create, in case the person or the company has a goodwill or brand in the market, then they can reap out benefits out of those marks. Okay, so the trademark can be given for a word, design, sign, symbol, shape, packaging, color, or combination thereof. And the only requirement that is required is that the mark should be capable of represented graphically. However, in present scenario, we have got registration of smell marks also. Okay, so since those smell, the component of smell can be expressed in terms of chemical formulas. Therefore, in US and Europe, the registration has been given for the smell marks also. We have also we have seen cases of getting trademark registrations for voice also, because we can write those voice in connotations. So in case we can, the only requirement is graphical representation. So in the voice expressed in these notes can be registered. So these are some of the signs which are registered. And if we talk about the term of protection, these trademarks are given for 10 years and they can be further renewed for 10 years till you are interested in using it. So although they are limited in time, but you can continuously renew these trademarks until you use, or it is of interest for you. Okay, and the right in these trademarks can be licensed or sold to other parties, either in part or completely. So by way of an agreement, you can assign your rights in these trademarks and to the other parties, subject to the provisions. So this is one of the example wherein, I mean, from Kenya, wherein they have no used the law, I mean the law of trademark for promotion and betterment of a community. Okay, so if we talk about the trademarks, in the, I mean, this is an example of Taita baskets. So these Taita baskets of Taveta County in Kenya, they are a symbol of reputation when we talk about when we talk about the quality and reputation of, I mean, these baskets which are made from sisal plant. Okay, so I mean the cultivation of sisal plant, there is in that, I mean, Kenya is a old age skill wherein they have gained an expertise in developing these baskets from from the fibers of sisal tree. So they have got registration of these Taita baskets as collective mark, and the association which is taking care of, I mean, all these activities to promote the people who are doing it, and to ensure that the proper quality is being maintained, because reputation is attached to the goodwill of the mark. Okay, so this is an example of preserving traditional knowledge and supporting the indigenous people by way of trademarks. So another IPR that we are going to discuss is designs. Okay, so the designs are completely aesthetic in nature. Okay, the physical appearance of an industrial good is registered under designs. So though, I mean, these are the way, I mean, they look. Okay, the way the look or the design which we can perceive from the eyes is registrable under designs. So the designs can be registered, I mean, these for shapes, configurations, surface patterns, or ornamentations. If we see the composition of lines on certain item, I mean, or a product, or lines or colors, they are also, I mean, registered under Designs Act. So the only requirement that is, I mean, prescribed under law is that the design should be applied on that article by way of any industrial process. Okay, and that process can be manual, mechanical, or chemical, or a combination of these. So there must be an article which is the product. Okay, then there is a design put onto that product, which can be a shape, configuration, pattern, or lines, or any designs. Okay, and that application should be through a industrial process. Okay, and there is a restriction that, I mean, the right is only given to the visual appeal of that article. Okay, so if you talk about the functional parameters, the right is not in the functional parameters, but only in the visual appearance. Okay, and protection for designs is given to commercial and industrial use only. That is not for the artistic nature. Okay, so if you talk about, I mean, the design on this shoe, it has an artistic creature. Okay, but once it is applied to this article, which is shoe, then it becomes a subject matter of design. However, before applying it, it might fall under copyrights also. Okay, so the only, I mean, the essential requirement under designs is that the design which is applied should be original. And when we talk about originality in designs, as per section 2G, it says originality in relation to a design means originating from the author of such design, and includes the cases which, though old in themselves, yet are new in their application. So if we talk about this design which is applied on the shoe, might be applied on some dress previously. Okay, so when we apply that design on the shoe, it becomes original with respect to the article. Okay, so it has the originality of application with regard to its application on shoe. However, it was previously known for being applied on some cloth. So this is how originality in design is considered, because the element of putting this design on shoe requires a different skill. Okay, so putting this design on shirt is different from putting a design on shoe, because it requires putting these motifs and designs properly so that it looks aesthetically fine. Okay, so apart from these things, I mean, there are certain objects, I mean there are certain prohibitions wherein, I mean, the designs are not granted. So if we see, the first prohibition is like the design is granted for the aesthetic outer appearance. It is not granted for the inner portion, which is not visible or noticeable by the person who is looking at it. Okay, building and structures, they are prohibited from being registered under Designs Act, part of an article which cannot be sold separately. Okay. Okay. Then variation variations which are common in trade, they're also not registered. Stamps, labels, tokens, medals, trademarks and cards, cartoons, these are also not registered under designs. Okay. Then in case there is a mere change in the design, we have a miniature design of a car which is already exists, then there is no right given in the miniature, because the variation in size is not an doesn't qualify to be registered under designs. Likewise, emblems, flags, flags of nations, computer chips, integrated circuit design, these are not registered under Designs Act. Okay, and if we talk about the duration of registration, it is registered initially for a period of 10 years, which can be further extended for 5 years only. Okay, after that, there is no extension, and the total duration is 15 years, subject to renewal after 10 years for another 5 years. So now the other, the IPR that we are going to discuss is geographical indications. So basically, if we talk about geographical indications, these are the indications which are used for goods, okay, goods which are originating in a specific locality or a jurisdiction, and there is a given reputation or quality which is linked to the geography of that area. So when we talk about Darjeeling tea, the term which is registered under GI is Darjeeling tea with its logo. Okay, so if in case we want to use either the word or the logo which is registered under GI, then it is essentially required that the tea which is traded under the name of Darjeeling tea must have been produced and processed in a certain locality of Darjeeling, which has been given under the which has been mentioned during the registration process. Okay, so there is a reputation or a given quality. So we all know that Darjeeling tea has a defined quality and reputation which exists in market, and it is linked to a geographical location in Darjeeling. Okay, and also linked to the specific way of producing that Darjeeling tea. Okay, so it gives an attribution to the geographical origin of this Darjeeling tea. In case somebody else who is not located in that geographical location uses the term or the logo which has been registered, then it is infringing the right, and a proper infringement suit can be filed against that party. So these GIs are basically used for goods, and these goods are basically they can be agricultural products, foodstuffs, wines, spirit drinks, handicrafts, or industrial products, and they are the collective and certification marks. So you can in a way control the quality of the products also. And once it is registered for 10 years, which is further renewable for another 10 years, and you can continue to renew it until you want to use it. Okay, and there is no provision for assigning the rights under GIs. You can be a registered user. Okay, so in case somebody who is living in that geographical location want to trading those products and want to use the mark or logo which has been registered, they have to file an application for being a registered user, and once they are registered, then only they can use the mark or the logo which is registered for the respective product. So as I told, if we talk about the types, there are these goods can be classified under agricultural, natural, or manufactured goods. When we talk about agricultural, these Darjeeling tea and the Erode turmeric are the examples. For likewise, for natural, we have several examples. And when we talk about manufactured, there are 3 subgroups. One is handicraft, manufactured, and foodstuffs. So these are the basic broad categories of products which are registered under GIs. So as I told, there must be a reputation of product. Okay, so with regard to nature or quality of product, there must be a distinctive reputation established in the market, and it must be linked to a geographical area. Okay, so if we talk about the agricultural product, they must be grown in that area, or in case we talk about the manufactured goods, then either of the one of the step which is essentially essential for creating the reputation must be undertaken in that geographical area. And the linkage between the geographical area and reputation should be evident with regard to the given quality or the geographical environment. And no doubt there must be a uniqueness, and you have to prove all these parameters by way of submitting text, opinions, or some evidences to prove. The best example of GI is, the most discussed dispute that happened in recent times was the dispute between Banglar Rasgulla and Odisha Rasgulla. So these two states, they they claimed against each other that these Rasgulla belongs to the respective state. However, after examining the applications, it was found that Banglar Rasgulla is characteristically different from Odisha Rasgulla, and and they both have different taste also. Okay, so based on the characteristics and the reputation that they have with regard to their own states, it was decided that separate registration will be given to both products, that is Banglar Rasgulla and Odisha Rasgulla, and both are registered separate GIs. Another example of traditional knowledge and linked to GIs is like, if you talk about the Varli paintings, these are registered at GIs in India, and the Varli paintings are traditionally practiced in the area of around Mumbai in Maharashtra, and it is a practice of painting painting walls, and these mud walls are painted with white paste. So they have a proper traditional way of making this paste, which comprises of rice, water, and gum, which is traditionally prepared, and the brush that they use is prepared from bamboo. After chewing the ends of a bamboo, these brushes are made. Okay, and if we talk about the the way it is created, it is not a mere art or a painting, but they express their life or their traditions by way of these paintings. So they, during the festivals and occasions like marriage, they paint their walls wherein they express the stories. Okay, so they have different motifs, they have different way of expressing their their traditions and cultures on the walls by way of these paintings. However, if you see the application that has been filed for registration, it has been filed under class 16, 20, and 25. So originally these paintings were put on walls. However, if you see the application, the claim has been made for using these Varli paintings on paper notebooks, cardboards, on furnitures made of wood, and canvas or cloth. Okay, so this is a this is an example of using traditional knowledge for contemporary usage. Like now that this traditionally known Varli paintings will be now used for all these modern products. Okay, so this was all about GIs. Now we'll talk about Plant Variety Protection Act. Okay, so so we have a sui generis law for protection of new plant varieties in India. Okay, so if we see the genesis of this law, it originated from the International Union of Protection of New Varieties of Plant, UPO, which was established in 1961. However, India is not a party to it because India had some critical requirements. Okay, so since farmers' right was not included in that model law given by UPO, so India not being a signatory to this UPO has enacted a sui generis law, which although replicates the essential parameters of the law prescribed by UPO, but it has some additional features also, like farmers' rights. So when we talk about registration of new varieties, then a variety must be distinctive, uniform, and stable with regard to expression of the characteristics for which it is registered. Okay, so with regard to the registration, there are 4 types of varieties that can be registered. So a new variety having novelty, distinctiveness, uniformity, and stability can be registered. For extant variety, novelty is not the essential criteria. However, distinctness and uniformity and stability is the requirement for being registered. Likewise, if you talk about farmers variety, novelty is not required, but other 3 parameters are required. And for essentially derived varieties, the genera or species should be specified by the central government. Okay, and with regard to the duration of rights, basically all these registrations, they give a right for initially for 9 years, which can be renewed up to a total of 18 years in case of trees and vines. However, I mean, for all other crops, the initial, the duration of registration is 6 years, which can be renewed up to a 15 years. Okay, the duration is different in case of extant varieties, wherein the right is given for 15 years from the date of notification of that variety by the central government under Seeds Act. Okay, so this was all about the registration of plant varieties. Now we'll discuss about the semiconductor. We'll talk about protection of layout designs of semiconductor integrated circuits. So when we see, some electronic item, we can see, there is a motherboard kind of thing. In layman language, we say it motherboard. Then we have some circuitry elements, transistors and other elements which are placed on that. And we have lead wires connecting these elements to each other. Okay. And this is how all these electronic items or circuits are being placed for an electric item. And see, if we talk about the transistors and these other elements, they are individually can be protected under patents. However, the layout design of these elements also plays a critical role, because if we see the size of a laptop, it plays a critical role. However, the designing of these integrated circuits essentially governs the size. Okay, so in case we want to reduce the size of an electronic item, the layout design of these circuitry elements plays a critical role, and it requires a huge amount of labor and investment. Okay, so it is essential to protect the layout design also. That's why we have a separate law which governs the protection of layout designs of semiconductor integrated circuits. Okay, and these layout designs in a three-dimensional disposition, can be protected. Okay, so basically the subject matter of registration of these, under this law is the outline which describes the transistors and other circuitry elements connected by lead wires. Okay, and the way they are expressed is protected under Semiconductor Layout Designs Act. And the registration is given for 10 years, and the essential requirements which makes a layout design to be registered under this law is like it has to be it must be capable of being distinguishable from others. Okay, so it must be different from the already registered or already known layouts, and there must be some inherent distinctiveness with regard to the arrangement of those elements. Okay, so in case these two parameters are not met, then it is presumed that it is not original in nature and it is devoid of protection under this law. Okay, and there is an exemption with regard to the commercial exploitation. Okay, so in case something is developed and an application is filed within 2 years, then that commercial exploitation is, that commercial exploitation will not kill the originality of that product. Okay, and in case we combine 2 or more layout designs to form a third one, which is sufficiently capable of being distinguishable from those two already earlier existing layouts, then it is capable of being capable of registration under the Act. And the duration is for 10 years, and the duration is counted from the date of filing application of first commercial exploitation, which is whichever is earlier. Okay, so now if we see all these IPRs that we have discussed, now each one of us would be sufficiently able to understand that this Coca-Cola bottle has certain elements. Okay, so the mark which is used to identify the product is a trademark. Then if we talk about the patent, the lid which is being used on the on top is patentable. The design of this bottle is protected under Designs Act. Then we have some graphical elements which are artistic creations of authorship. Then those things are copyright protected. Then we have this bottle opener, which is an invention protected under patents. And the last thing that we can talk about is trade secret. The recipe of Coca-Cola, which is protected and protected from a very long time, is protected under trade secret. Okay, so there is no law in India So, I mean, this is governed basically by the Contract Act and the agreements that we have with our employees and the people who are involved in the production of, these compositions. So now to summarize it, now we have gone through each IPR, and now we can see that there are certain conceptual similarities in IPRs. So when we talk about the product and processes, the subject matter of these IPRs are either product or process, okay? And they have a defined criteria of protection. So they basically have essential parameters that are to be met, and there are certain prohibition with regard to the qualification with regard to protection. They confers exclusive right to the owner, okay? So they have a they give an exclusive right to the owner, and they include negative rights to exclude others also, okay? So there are certain limitations and exceptions wherein these rights can be used for some specific purposes without authorization from the owners also, and they are basically limited in time, okay? If we talk about trademarks or GIs, they can be renewed for indefinite time, but they have to they are renewed for a certain period of time at one point of at one instance. So basically they are limited in time, and in case you don't want to register, then the rights will vanish, okay? With regard to differences, there are different requirements, okay, for registration of these these items. There is a requirement of grant also. If we talk about all the IPRs, there is a requirement of grant. We have to apply, and then only these IPRs are, and the rights under these IPRs are granted, except copyrights, wherein the right is the right exists per se. The moment you create something, you express it on a tangible form. The right the right of copyright, it creates therein, okay? So it's a statutory right given without any registration, okay? So there are certain conditions of protection which are different in all IPRs. Then the nature of rights are also different. Then duration of protection granted varies. When we talk about the artistic creations, the length is very high, okay? So if you talk about the copyrights, the duration of copyright is like the life of the author plus 60 years, which will start from the next calendar year. So it's a very huge, because there is an artistic creation. However, if we talk about the talk about the IPRs which have more commercial nature, then the rights are less, like we have in designs and other IPRs. So this is the basic summary, wherein copyrights can be granted for literary, musical, artistic works, okay? Then patents can be granted for inventions like drugs and vaccines. Trademarks can be given. Trademarks, including certification and collective marks, can be given for products and for products having a different science to to identify them. Then GIs can be given for the products having no specific reputation and quality linked to a geographical location like Darjeeling tea. Then we have industrial designs which are given for aesthetic appearance or look, like the design of a basket. Then we have layout of integrated circuits, which are basically given to the designs of layout, like mask works in circuits. Lastly, we discussed about the plant varieties, okay? So these plant varieties are granted for new plant varieties like Hansraj rice, okay? To summarize, we must understand, we all now understand that IPRs, they are protected for the creative and creativity of the authors. And if we talk about patent, designs, and copyright, they enable creators and innovators to get recognition and commercial benefits out of it. However, if we talk about trademarks and GIs, they help to differentiate particular goods and services from the other ones. Basically, if you talk about GIs and trademarks, they are helping the consumers also. So these laws are consumer specific, and they are enacted with to protect the rights of consumers also. And by way of by using these IPRs, we can convert our creative ideas into assets. And in a way, these IPRs are helpful in protecting the traditional knowledge also, not completely, but some of the elements of traditional knowledge can also be protected under IPRs, okay? So in case we protect our creations through these IPRs, it will definitely boost innovation. It will lead to further enhancement of the creativity, and no doubt it also helps in the enhancement of growth, okay? So the entities which are using IPR for in their trade have more incomes as compared to the companies which are less less which have less interest in IPRs. And finally, I mean, these can be used for branding of the products and to to make a presence in the market with quite good financial returns. So this was all about the IPR, and we have almost touched upon every IPR. And now, in case you have any questions, we can take those. Thank you.
Thank you very much, Dr. Anilji, for this fantastic presentation. I mean, it was the first time I had a time to, I had a chance to really look at it carefully, more carefully than last time. So it was fascinating to know the nuances involved in copywriting and patenting and all of that. So thank you very much. Mr. Janerji, would you like to say anything? And then we can open it up for questions.
No, not any. So the only thing is that I would request all the participants to hold on to their patience when it concerns IPR matters on traditional knowledge, because tomorrow and the day after we will be covering at length the aspects of IPR and as well as ethics on traditional knowledge. So today we'll have the forum open for general questions related to IPR.
Okay. Can I open up with a question? I mean, this is a question that's been on my mind. It's a very layman's question, but I'll ask it nonetheless. So the question was regarding products like Haldi. So there was at some point this whole noise about somebody in America trying to patent Haldi, which has been, a household product at our end. So I was just wanting to know, like, at what point, like, what was the basis on which they were suddenly claiming a patent? And because we are using these things on a daily basis, we don't even necessarily know the innovative value of it, or I don't know how do you want to put it, but the special value of it for marketing, or we don't even realize that. And so if some other country decides to come and take up one by one, then what are we supposed to do? Are we supposed to suddenly decide that we want to patent every single thing that we are living with because it has a unique value? So how would you address an issue like that?
We'll address it tomorrow, Anuradha. You'll get you'll get to hear a lot about all these, including Haldi story.
Okay. Okay, just regarding today's presentation, there was another thought that struck me, and I don't know if you mentioned it more in detail. But like, for example, the shoe design, you were talking of the shoe, and you said that somebody who has a design on a cloth versus a design on the shoe. So the application of the design on the shoe is unique than, when it is on a textile. So my question there would be that what happens to the one who has created that design? Now, whoever's created that design finds application in a shoe and in a cloth. So how does that work?
See, basically, when we design something, so it falls under several IPRs. So when we make a design on paper, it is an artistic work. And the moment it is created, the copyright starts. Okay, so whoever designs that, make the design on paper, so that design on the paper is a copyrightable subject matter. Okay, then that design is applied on a shirt. Got it? So once we apply that design on a shirt, the copyright also exists there, because you have to change the design as per your the requirements of the shape. Okay, so you have to put a motif on the shoulder and all those things. So there is a creativity in it. Okay, so now the intersection of copyright and design starts. Okay, so once you apply it on a commercial product, which is a shirt, then it has both elements, copyright and design. Okay, so copyright law says, in case something which is artistic in nature, okay, and is reproduced more than 50 times and was capable of being registered under design also, then you have to register it under designs. Or else, the moment you create 50 items of it, you lose the copyright, and you have not taken design also, then you lose copyright and design both. Okay, So the design on paper is a copyrightable subject matter, but once it is applied to a shirt, it has to be registered under Design Act. In case you want to have more than 50 copies of that. Okay. So in case there are less than 50 copies, then copyright exists in the shirt also. Okay. And this is the whole phenomena wherein these designers, they, protect it. If you see in 2018, Sabyasachi Mukherjee, okay, you know the famous designer, he got the award for filing maximum number of designs. So this is how, there is an interplay of IPRs. I hope I answered your question.
So even for the shoe, you had to take a design. So
You have to
had
take a
apply
design.
for the design
And for
registration.
shirt, there will be a separate design registration. And for shoe also, there will be a separate registration. So these are two items that will be registered under Designs Act separately.
Sorry, if I understand, that was wonderfully explained. If I understand it clearly, then for just the making of the design itself, without its application on a product, just the design component itself has a copyright value. And as soon as it is productized, then one has to again file for a design right.
Yes, yes.
Okay, because that design gets modified in different products, and therefore there is
Yes.
a reconceptualizing of that design in application, and that is why one has to again consider that. So a win-win situation for IKS artists would be to create the the design copyright initially, like the copyright for the concept, and then productize it at least in one place. No,
So you
that's
have infringement also in terms of designs and all that. So that's a very long story. So if in case it is, in terms of unfair commercial benefits that leaves the, original inventor out, you can go in for a legal action, and the court might give appropriate measures to take care of the inventor's creativity. But then that's a long story.
But we have also, we must also ensure that the design that has been applied on shoe is not a substantial copying of somebody else.
It
Then you
cannot
are-
be a mere copying. So
Yes.
they'll have to adapt it to the particular new item.
Otherwise, you are infringing the copyright of the person who has designed that.
very interesting. I mean, these nuances, no, because people are playing around with the original. So I was just in the IKS context because I have not yet seen any questions. If anybody has a question, please raise your hands, and we'd be more than happy to unmute you and ask.
In fact, it is not within the IKS, even outside of the IKS also. There are many things that are there. So the example that you have given, even in terms of the design and all that, so there can be, very similar copies. Okay. So even similar copies can go in for kind of infringement, and you can go for a legal action.
Yes. No, I was the reason I was talking of in the IKS context is because, like, I know that the Lepakshi weavers, I'm just talking of, what is there and how you would see it from this perspective. So the Lepakshi weavers, in the saris that they make, they very typically borrow the motifs from the temple motifs that are there. So when somebody is wearing a Lepakshi weaver sari, they're literally bringing alive the motifs of the temples. It's a very beautiful way. So I'm wondering how that would, whether that has any thing to do with this whole rights and all this business, like.
No, what
that-
is already known, like, even they have taken the motifs from the temple. So you have yourself clarifying that there's been a prior art that is already available. They have applied it. So it is a skill of the particular person that comes into, the action when it comes to identifying the ownership rights. But in this case, to protect the rights of such people, the geographical indications can come in play. So by giving a geographical indication to that particular Lepakshi, say Kalamkari sari, so you are protecting the rights of those artisans. Okay, the GI provides you branding And the premium, because there are certain specifications that need to be followed. The quality needs to be ensured. So only when all this is there, and if it has been given a GI tag, you can use the GI tag and brand your product appropriately. But what is prior art that is available to one and all.
So anybody, like I can go and utilize that same design and it's not a problem. But if
It's not
a
a problem.
Depakshi weaver decides to, claim a copyright on that, it can't be a copyright. I don't know how a design copyright or whatever, because they're applying it onto a product of their sari. So supposing they do that, then does it get into a legalized situation if somebody
They
else
may
wants-
not be given the copyright of the design because it's already there in public domain. Okay, so one particular person, no one single artisan can claim ownership to such thing. So to protect the, the livelihoods of such people, the geographical indications do come in. Even that's an intellectual property right, geographical indication.
Wonderful. Thank you. Are there any other questions from any other participants? I'll just repeat the fact that one of the reasons why we are having this course in collaboration with TKDL team is because with a lot of projects that are being granted by the IKS division, there's a lot of new knowledge that is coming up in the IKS domain. So how do you protect your rights in those IKS with those new knowledge that's coming up? Centers are working on it. Individual research projects are happening. People have already been working. It's not that the IKS division has any claim to first being doing all none of all of that. There are a lot of people who are already working on indigenous knowledge traditions, and therefore I think this becomes very valuable to understand how to be careful about our content. So somebody, Dr. Abhijit Mukherjee ji is asking how duplicate items can be prevented through IPR.
So when we talk about duplicate items, so there can be a duplication of an invention. Okay. So in case there is a copying, or I mean using the invention, then it is an infringement of Patent Act. So a proceedings can be initiated for the infringement of the invention under Patents Act. But in case we are talking about the two similar items wherein the brand name is being misused. Okay. So we have shirt wherein a trademark of somebody else is being used. Okay. So then in that case, we have to file a case of infringement of trademark in case it is registered, or a civil suit for passing off in case there is no registration, because there is a common law on trademarks also. So this is for the copying of a mark. Okay. You are using, copying that product with the mark also. Okay. So with regard to the copying of a design, similarly, you can bring a suit in case it is a registered design. So we have to get a proper clarification as to what is the copying. So there are certain elements which are covered under respective IPRs. So the element which is infringed under that IPR, then we have to bring the suit or infringement proceedings under that law, which is prescribed.
Yeah, and also, even before you are granted any IPR, the patent office makes sure that, prior art is checked before they grant you any IPR, be it patent or trademark or copyright or design, any such thing. So no two items can be given IPR on the same matter. There is one more question, Anil. Somebody has asked, how can a recipe be protected as a copyright?
So in case, there is a recipe, okay, for production of certain good. So in case it is quite innovative, okay, and it qualifies to be an inventive, it is not disclosed prior to that, and it has no inventive step in it, and it has an industrial application and other requirements, then it can be patented also. The process itself is patentable in case it qualifies all the essential requirements. Moreover, some element of this can be protected under GI also. In case there is a traditional way of producing that product, okay, and it has a reputation attached to that location, okay, we have certain food items which are linked to certain geographical indications, so that can be protected under GI also.
Very true. And in terms of the copyright, you would have seen many of the chefs creating their own books. So such books are copyrighted. Okay. So here again, like what Anilji had mentioned, copyright has its own way of protection. So it is up to the author's lifetime plus 60 years or 50 years, depending on the jurisdiction. So here, the problem of, any recipe or, food matter is about enforcement of the particular IPR, right? If say I look at a patent and I prepare the same food in my house, there's nobody who's going to come and check whether I've used the patent information or used something else. So when we are talking of industrial property, it's a very strategic measure that we take to ensure that, whatever has industrial applicability and enforcement, those need to be, filed for IPR, because IPR being legal provisions are very, very expensive, and it is a very long, time-taking measure. So one has to be very, very judicious when we are strategizing about taking intellectual property rights.
There's a question here about the Darjeeling tea. And is it the product of GI tagged and the logo trademarked, or both together comes under GI? This is by Dr. Rajni ji.
See, when we talk about Darjeeling tea, it's a GI. So in India, it is registered as a GI. However, in some of the jurisdictions, they don't have a law to govern GIs. So in those countries, it is registered as either collective mark or certification mark also. Okay. So it depends what country provides which law for protection. So in India, it is a GI product. It is protected under Geographical Indications Act.
There are a few questions that have come up in the course of the our deliberations, I guess. But I'm just wondering to what extent we can take questions. It's already almost 5:20. Would you like to take a few more? Should I try and club some questions together? Would you like to try answering them?
Would it be okay that I leave because there's another meeting? Anil will be there to provide the responses.
Is it all right that we continue a little longer, or maybe another
Yes,
5 minutes or so, and then we can try closing, no? Maximum up to 5:30, because I think people also start leaving. So maximum 5:30, whatever questions get answered, and then we'll take them the rest later on. That's good. Okay, thank you very much.
Thank you so much. Thanks to all the participants too. Thank you so much.
So Anilji, if I may just continue with the questions here. There was another one by Firoz Ahmad ji, who's saying that is there any other benefit the weaver is getting using the GI tagging besides having authentic items?
See, if we talk about geographical indications, these are basically for the protection of consumers also. Somebody who is somebody who is located in a jurisdiction wherein a product which is related to weaving is registered, then one benefit is like, in case you have a product which is registered under GI, there is a premium attached to that. Okay. So if we talk about Banarsi sarees, so there is a premium when we talk about, when we go to market and we look for some products. So if the saree is Banarsi saree, it has a premium attached to, you have to pay additional amount in terms of the money which is paid to the paid for that product. Okay. So in a way, it is basically benefiting the weavers. Okay. We all know that way of weaving through those traditional ways is very laborious and time consuming. Okay. So producing a sari in industry and producing a Banarsi sari by hand, so there is a cost attached to that product. Okay. So that's the reason GI protected products have a premium as compared to the commercially produced products. Okay. So the whole concept of having GI law is like that. You have to protect the rights both of the consumers and of the producers. Okay. So whoever is producing those products within that geographical location, that is Banaras. Okay. So they will be using those logos and marks which have been registered. So in case somebody else who is not using or residing in that geographical location is using, then he is infringing the rights. Okay. And there is a provision of registering these weavers as registered users. Okay. So the right which is granted under GI is a collective right. So some association who is furthering the right of these weavers is the basically the owner. However, there is a provision of these weavers to get linked to that application as a registered users. So only those registered users can use, and there is no monetary benefit which usually people get when they are manufacturing goods which are GI protected all across the globe. I hope I answered the question.
I may just ask in continuation to this, we heard it's in the air that China, it seems, took a few of our Banarasi sari makers to China and learned the art from them and either send them back or didn't. That's a different story. But paid them quite handsomely for a short while because there's a shortage of money circulating regarding Banarasi sari for the traditional weavers. It's a whole problem in itself because of the industrial Banarasi sari market that's come up. People want cheaper rather than things like that. So now the thing is that now that China has learned the art in a sense, and they are producing so much of it. So is there any way that India can claim any kind of a copyright issue, something from them, or is there something on those lines that can happen?
Basically, when we talk about GIs, the right is given to the use of a mark or name. So there are limited rights. However, underlying those marks and logos, there is a whole lot of new process which is used by the weavers or the producer of that GI. So the protection is basically granted for the use of Banarsi sari or the logo that they have registered. Okay. So the China copying or using the same motifs or designs to produce something which looks similar to the Banarsi saris, that is possible. They can do it. Okay. But they can't use the name. Okay. So they can't label that product as Banarsi sari or use that label. The logo which is registered. So basically the consumers, they identify products by the name. Okay. So basically this is a protection given to, to protect the source from where it is coming. So in case they're using these two things, then the case of infringement can be brought against the manufacturers in China also. In case it is also, this protection under GI is also taken in that jurisdiction, because all these laws, they are jurisdiction specific. So when we talk about GI, then we have to register that product in that jurisdiction also, so as to bring a suit in that country. So first essential parameter is we must have a GI registered in China also in the same name and logo. So that's the reason outsider, the producers from other countries, they're coming to India to register their products as GIs because they see a potential market in India for their products.
There's another question by Dr. Arjun Singh Ji, who says that can GI and TM applied / obtained be obtained simultaneously? We can't hear you. Anilji, for some reason, your voice is muted.
Yeah. Yes. So law is very clear. It's very difficult to register a single item under two laws. Okay. So when we register something under GIs, then trademark is not possible to, you can't secure trademarks in India. So these are two different items. Okay. However, the subject matter is different. In case you register, for example, to take some example, you register a product under trademarks. Okay. So the right granted under trademark is for the use of that name or label that you are using. However, in case you want to register under GI, then protection will also be granted for the reputation that has been established. Okay. So the characteristics of good, the reputation and quality linked to the mark is protected. Okay. But simultaneously, both can't be registered in India. That's not permitted.
Then we've got Dr. Hemant, who's asking how the IPR works if someone puts a classical medicine of Ayurveda mentioned in Ayurvedic texts in a food product or toothpaste, etc. If someone puts ashwagandha in dalia,
So
Correct.
hopefully this question will be answered tomorrow. So all IP related, I mean TK related IP will be discussed tomorrow. So I hope, I mean, it will be answered tomorrow.
is Namdevji has something on similar lines, I think, where he says, can you please elaborate IPR right in natural drug discovery?
We'll answer this tomorrow. We have a detailed, presentation on this.
Okay,
How
then
IPRs and TKs, I mean, they have a interconnection.
yes, Dr. Arjun Singh ji, he continues this, can TM be applied for abbreviations of description words?
Yes, it is possible. It is possible, provided it has a distinct presence. So something which is similar to an existing mark is not granted. So there are basically two type of restrictions with regard to trademark registrations. One is absolute, objection under section 9, wherein in case you are using a name of a place that is not registrable under Trademarks Act, in case your name, it signifies the characteristics of the product, that is also not protected. National emblems and all those things are not protected. This is absolute objection. Then section 11 objection says, in case your mark is similar to an existing mark, then it is not granted right under Trademarks Act. So whatever way you express it, okay, in case it is distinct from the earlier existing things, it will be granted. Whether it is abbreviation or not, it doesn't matter. And yes, abbreviations are getting trademark registrations. There are cases.
And just take this last question, and it seems like the last question also, besides a lot of appreciation for the course, a lot of gratitude coming your way. So Dr. Arjun Singh is saying that whether any patent application refused in the US 15, U/S15 can be reapplied for reconsideration for patent.
See, it depends. Okay. So once you file a patent application in US, so that application will be published in US. Okay. And in case it is not granted and you try to get a patent in India, so first thing is you have killed your novelty, because that publication in US will come, okay, on the way in India also, because that invention that you are claiming should not be disclosed, okay, anywhere in the world. So rights are jurisdiction specific, but in case, if you see the novelty, it is global. Okay. So once it is published in US, you have lost your rights in the in that invention. And since it is published there, so the application that you will be filing in India will be it will kill the novelty of that application. It will not be granted in India. So once you want to file a patent application, you should not disclose it before the grant, because in fact your own disclosure will kill the novelty of that patent application.
So thank you very much, Anilji. I'd just like to make a small announcement here. We've created a Google Drive link here, and in that we plan to put the PPT of the previous day, and you will also receive a mail with the PPT of that day. But this Google Drive will have the PPT, and it will have a Word document, which will also contain the YouTube links as well as the web link for the next day. So we've faced some trouble with the emails of certain participants, which have bounced back. So whatever emails you've given, for some reason, the mails are not reaching you, and therefore you're not getting the link for the next day. So I suggest that if you can keep this web link there, then you can also access the link for the next day on this Google Drive link. All right. So it's shared here. Please make use of that. And since all the PPTs will be coming in for the next days, all right, not the next day, the previous day's links, the PPTs will be there, and the next day's link. I think not to confuse you too much. All right. So, and for the certificate, as we had mentioned at the beginning, 80% attendance is mandatory, and also that the assessment, after the assessment, those who get 80% above will get a merit. All the others will get a participation. Those who've attended the first time can attend again. All the content is being shared with you. And the certificates are likely to come in the first week of September. Please give us some time. We are a small team and hands overfull. So please bear with the little delays from our end, but we'll try our best to be as prompt as we can. All right. So we've got Madhushri ji who's asking a question, but I'll request you to please be back tomorrow with us and ask the same question in the beginning. All right. So we'll stop here and I'll stop with Anilji, with your permission. Is it okay if we can stop here? Thank you very much. As we've said that these are actually 1 hour sessions, but I'm suggesting that you be ready for 1.5 if you want to get the full thing. Otherwise, you can catch up with the questions and answers that happen on YouTube. So please stay with us because this is fascinating stuff and very important for anybody who is working in this domain of traditional knowledge. So with these few words, we'll end with the Shanti mantra here. Om Sarve Bhavantu Sukhinaha Sarve Santu Niramayaha Sarve Bhadrani Pashyantu Ma Kaschit Dukkha Bhag Bhavet. Om Shanti Shanti Shanti. Thank you very much. See you all tomorrow.
Thank you, everyone.
Thank you.